The subcommittee will come to order. The chair will recognize himself for an opening statement. First, I'd like to thank my colleagues on both sides of the aisle for being here today for what promises to be a very interesting hearing. The new Republican majority has stated its commitment to an open and fair legislative process, and that will be reflected in this subcommittee. I ask all of my colleagues and our audience to treat each other and our witnesses with civility and respect. This hearing is an important part of the legislative process, and we will conduct it accordingly. I'd also like to acknowledge my friend, the ranking member, Mr. Pallone of New Jersey. Pennsylvania and New Jersey are as close together as the Phillies and the Yankees are far apart. This Phillies fan intends to work as closely as possible with Mr. Pallone, the Yankees notwithstanding. I believe there are a great many things we can work together on for the good of this country, and I look forward to cooperating with you this year. When we disagree, I hope we will also always do so with dignity and respect, treating those who may disagree with dignity and respect, and I promise to do that on my part. Pursuant to committee rules, I intend to make an opening statement of not more than 5 minutes, and will then recognize the ranking member, Mr. Pallone, for an opening statement. The chairman of the committee, Mr. Upton, will then have a chance to give an opening statement, followed finally by the ranking member of the committee, Mr. Waxman. Today we will hear testimony from one panel of 3 witnesses, 2 invited by the majority and 1 invited by the minority. All sides of the debate will be heard today, and every member will have a chance to question each of the witnesses. The testimony we will hear today regards the prohibition of taxpayer funding of abortion and abortion coverage. For decades, there has been a clear prohibition against the use of federal dollars to pay for abortion. The Patient Protection and Affordable Care Act opened the door for the first time in decades to government financing of abortion. My colleagues will recall that the House acted affirmatively to fix this in a strongly bipartisan vote of 240 to 194 to 1. We are all aware that abortion itself can be a controversial subject. What is far less controversial is the question of whether the taxpayer should be financing it. The so-called Stupak-Pitts Amendment last session affirmed the view of 60 to 70% of Americans that government taxpayer money should not be involved in abortion. Unfortunately, the Senate did not see fit to include the House prohibition in its version of the bill, and it was the Senate bill that became law. We need to be clear about some things as we start. The government does not finance abortions and has not done so for decades, thanks to the Hyde Amendment. Moreover, the government has never told any medical professional or medical institution that it must perform abortions. This bill seeks to clarify these policies and give them permanence. The President has, on at least 2 occasions, affirmed what we are doing here today. In his 2009 speech to a joint session of Congress, the President said, and I quote, "Under our plan, no federal dollars will be used to fund abortions and federal conscience laws will remain in place," end quote. A year later, in his executive order, the President clearly endorsed the principle of no government funds going to abortion, and again, clearly endorsed the principle of not forcing healthcare professionals to act against the dictates of conscience. But an executive order is not law. It can be rescinded at any time by this or any future president. It can be overturned by a judge or simply ignored. If we wish to respect the views of those who do not want their money used to finance abortion, if we wish to follow the wishes of 60 to 70% of Americans who believe the government should not pay for the procedure, then Congress should send this bill to the President in short order. The President is clearly on record supporting the principles in the bill, and when it gets to his desk, I hope he will sign it. I think I have, how much time? 40 seconds. I'll yield the remainder of my time to the gentleman from Ohio, Mr. Latta.
I thank the chairman for yielding and for holding this very important hearing on the Protect Life Act. And as the chairman designated in his opening remarks, stating that the majority of Americans are opposed to the federal government funding abortion. And the question, of course, that came up during the bill, the Obamacare legislation, as to the use of federal taxpayer dollars to allow that coverage, and also for the Stupak-Pitts amendment that was first supported, and then unfortunately we did not have, and then of course the executive order. So, and I'd just like to say, Mr. Chairman, that we have to be vigilant in our defense of human life and work to pass the Protect Life Act so that the government funding is not used to pay for abortions through the federal government. The anti-life policies cannot be tolerated, and it's because it's absolutely morally wrong and imposed by, again, as I said, the majority of taxpayers. The passage of the Protect Life is the first step towards putting an end once and for all taxpayer funding of abortion, as well as fixing a deeply flawed health care bill. And I look forward to hearing the bill becomes law. I yield back.
Gentleman's time's expired. The gentleman from New Jersey, the ranking member, Mr. Pallone, is now recognized for 5 minutes for an opening statement.
Thank you, Chairman Pitts. I look forward to working alongside you as well in the subcommittee, and it's my hope that we can meet some common ground during this Congress, and I appreciate the comments you made in that regard. I just want to say briefly, I remember the time when I told you that I was going to the University of Pennsylvania farm in your district, and I had a grand old time there with the pigs and the cows and all the other farm animals. And you represent a good part of Lancaster County,
all of Lancaster,
which is a wonderful, peaceful, quiet place. The Amish, and it's just a nice place. So let's work together. I definitely think we can. Regardless of any one person's views, though, on the topic today, I want to stress that current law is clear. No government funding can be used for abortion under the Affordable Care Act, except in cases of rape, incest, and to save the life of a woman. And today is not about public funding, in my opinion. Today is an attempt by my colleagues on the other side of the aisle to reopen the contentious issue of abortion and dismantle the landmark health care law. The bill before us, in my opinion, is too extreme. It's a massive overreach from what was delicately negotiated during health reform, and it extensively restricts women's access to reproductive health services and life-saving care. Its language does more than prevent federal funds from going to abortions. It's a step towards eliminating a choice that our Supreme Court has deemed legal and remains legal to this day. Religious and personal views should not put women's lives at risk. Under current law, healthcare providers are obligated to provide emergency services, otherwise stabilize a patient, and make available a transfer to another facility should they take issue with performing abortion procedures. This bill eliminates these minimum moral obligations, even to save a woman's life. The bill, in my opinion, is not pro-life, it's anti-woman. The same members of this committee who voted to repeal the Affordable Care Act last month charged that it will interfere with the doctor-patient relationship. And I can't think of a policy that is more intrusive of a doctor-patient relationship than the one before us today. I strongly believe women need and are entitled to safe, affordable health care options, and this bill only serves to create health and financial challenges that may be impossible to overcome. Now, whatever time I have left, Mr. Chairman, I'd like to yield a minute each to Ms. Capps, Ms. Baldwin, and Ms. Schakowsky in that order. We'll see if we can accommodate all three in my time. And so I would start with Ms. Capps.
Thank you, Mr. Pallone. As you just stated, the notion that the Affordable Care Act allows for funding of elective abortion is false. So I must ask, with national unemployment at 9% and the potential that we have right here in this subcommittee to create and strengthen a critical healthcare workforce, the jobs there, why are we here debating this extreme legislation that would instead take reproductive rights away from women? Mr. Chairman, the debate today isn't about tax dollars or provider conscience. Instead, it's about chipping away at the legal rights of women, including the right to receive life-saving treatment or referrals from a hospital emergency room. Not even the Stupak amendment we fought over last year tried to change this. It is disappointing that this committee, one that is so important to job creation and the economy, is wasting our time on this extreme legislation, and it's downright appalling that we are spending our first hours as a subcommittee in this Congress trying to restrict a woman's right. Now, instead of rehashing the culture wars, we should be using our time in the subcommittee doing what the American people really want us to do, strengthen the economy and create jobs. And I yield to my colleague, Ms. Baldwin.
Thank you. I share your concern that the very first hearing that we're having in this Congress isn't about creating jobs or bolstering our economy or helping families get health care coverage. Instead, the majority has demonstrated that its top priority is attacking women's rights. This legislation takes away a woman's ability to make their own important life decisions about their reproductive health. And this bill gives the government and insurance companies new power to make these decisions for them. And for that reason, I think this legislation is extreme. This legislation is an unprecedented display of lack of respect for American women and for our safety. The bill would cut off millions of women from the private care that they have today. It would deny individual decision-making by giving insurance companies more power, and it would allow public hospitals to deny life-saving care and dictate what women can do with their own health care dollars. With that, I would yield time to Jan Schakowsky.
I'd like to use that time to ask the chairman if I could offer for the record from the Catholic Health Association a letter which takes exception with some of the provisions, one of the provisions of the bill, and also from the National Partnership for Women and Families and the National Health Law Program.
Without objection. Be added to the record. All right, the gentleman's time has expired. Thanks. Thank you to those who made statements. And now the chair would recognize the chairman of the full committee, Mr. Upton, 5 minutes or such time as he may consume.
Thank you, Mr. Chairman. I intend to use 1 minute and then yield 2 minutes to Dr. Burgess, a minute to the Vice Chair, Sue Myrick, and a minute to Kathy McMorris-Rogers. So in my minute, I want to, again, thank you, Mr. Chairman. The discussion draft before us closely tracks the Stupak-Pitts Amendment that the House adopted by a strong bipartisan majority in the last Congress. This includes the Hyde Amendment language that has continuously been adopted by Congress since 1993. Unfortunately, the massive health care plan that was ultimately enacted by Congress contains numerous loopholes that allow federal subsidies to be used to purchase plans that pay for abortions. This bipartisan legislation today, proposed by Chairman Pitts, amends the health bill to clearly and statutorily prevent federal funding for abortion or abortion coverage through government exchanges, community health centers, or any other program funded or created by the new law. Additionally, the bill protects the right of the conscience for health care professionals and ensures that private insurance companies are not forced to cover abortion. I ask unanimous consent that my full statement be made part of the record and now yield to Dr. Burgess.
Without objection, so ordered.
I thank the gentleman for yielding, and just a couple of observations as we take up this legislation today. The Protect Life Act is not applying anything new. It's not applying restrictions. It merely extends the status quo. The taxpayer dollars will not be used to subsidize elective abortions, and that's it. Similar language is found in the Hyde Amendment, was passed in 1976 and has been reauthorized in each Congress throughout the appropriations process. H.R. 358 is only preserving language that Congress and doctors and patients have relied upon for decades. It does not change or alter the practice of medicine or the responsibility of physicians in any way. Past and present, the Congress has said we will not pay for elective abortions. That does not change in this legislation. Now, in my prior life, I was a doctor, I am a doctor, and I'm an OB-GYN, and I do value the sanctity of human life. I do believe that it is a miracle that it can even occur, and for us to interfere in a harmful way is something that, as an OB-GYN, I think is wrong. But I understand that people do feel differently. I think it is important to codify with this language that we are responsible for the judicious use of taxpayer dollars. Now, as a doctor, I'm sworn to aid those in need, and I reject where people say that this legislation would prevent doctors from providing care in times of need. Integrity in the relationship with patients, upholding the oath that we all take as physicians, are fundamentals. Arguments that people will be harmed, let alone left to die at the door, are just simply not true. There is a suspension of belief required to think that elective abortions versus medically necessary procedures can be, in fact, commingled. I see my time is at an end. I will yield to the
Vice Chairman
Vice Chair.
Sumarek.
Thank you, Mr. Chairman. I'm pleased to speak on behalf of this bill, and I believe it represents a necessary improvement to the Patient Protection and Affordable Care Act that was signed into law last year. Americans broadly agree that taxpayer money should not subsidize elective abortions. This bill doesn't affect the legality of abortion services for American women. It's not a sea change from current policy. In fact, it merely carries forth what's already true for federal health programs, such as the Federal Employee Health Benefit Program, Medicaid, S-CHIP, and the Indian Health Service. To my knowledge, there's no evidence that the prohibition of coverage for elective abortions in these programs has negatively impacted women's health. I look forward to the testimony from our witnesses and yield back.
And the Chair recognizes Kathy McMorris Rogers.
Thank you, Mr. Chairman. I, too, want to speak in support of the legislation. If we're committed to health care reform for everyone, including women and children, then health care protections for children should start at the moment their lives begin. We agreed to allow children to stay on health care plans until age 26. We agreed to provide our children's coverage for pre-existing conditions and eliminate annual and lifetime caps. But what does it all mean if we're not going to protect them at the moment their lives begin? Two-thirds of women polled during the health care debate, representing all parties, races, marital statuses, objected to the federal government paying for abortions. I would urge all of my colleagues to join in supporting the Protect Life Act, and I yield back the balance of my time.
Chair thanks the members for their statements. The ranking member of the full committee, Mr. Waxman, is now recognized for 5 minutes for an opening statement.
Thank you very much, Mr. Chairman. I think we have to put this legislation in the context of this bill and other bills that are also moving in other committees on this very subject of abortion. Let there be no doubt about it. The objective is not to say that taxpayers' funds cannot be used for paying for a termination of a pregnancy. The objective is to say, the objective of all this legislation is to say, no woman will be able to buy insurance in this country that will cover a necessary medical procedure involving the termination of a pregnancy. Even though it's legal and it's a medical decision, now will be taken over by the Congress to be made for the women involved. The Affordable Care Act had a very sensitive, delicate balance, and it was drafted in the Senate by Senator Nelson, whose pro-life record speaks for itself. That law prohibits the use of federal funds for abortion, keep state and federal abortion-related laws in place. It would not allow government tax credits to be used to pay for abortion services. But this bill goes beyond that. It would provide that there would, in reality, be no insurance policy for anybody buying in an exchange for health insurance to get a policy that would cover the termination of a pregnancy, even when it's medically necessary. This is an assault on women's reproductive health and their constitutional rights to choose when to bear children. Mr. Chairman, I'd like to ask unanimous consent that I be able to yield 2 minutes of my time to Mr. Gett, who is not a member of the subcommittee, but a member of the full committee.
Without objection.
Thank you very much, Mr. Chairman. There are some days in Congress I feel like I'm in Alice in Wonderland where everything is upside down, and today is certainly one of those days. The extreme legislation that we are considering today is not just simply saying that there shall be no public funds for abortion. That's already the law. That's the Hyde Amendment. I disagree with the Hyde Amendment, but in the annual HHS appropriations bill every year, it says no federal funds shall be used for abortion. This was also protected in the health care legislation last year. Let's be clear about what this extreme bill does. What this bill says is, first of all, it does codify Hyde, which is far beyond current law. But secondly, it says that anybody who purchases an insurance policy, an employer or any American, male or female, who purchases an insurance policy that covers all reproductive services, legal reproductive services, now cannot have any kind of tax relief. So it's not about direct federal funding of abortion. We don't have that. We don't have that. What it's about is saying these indirect tax credits now will be interpreted as federal funding. That is the most vast restriction of a woman's right to choose that any of us will ever see in our lifetimes. And what it would lead to if it became law is that no individual in this country or business in this country could purchase an insurance policy that covered the full range of legal reproductive services unless they suffered essentially a tax increase.
Thank you,
It's
Mr.
wrong, it's intrusive, and we just need to call it what it is. Thank you, Mr. Chairman.
I yield the rest of my time to Ms. Schakowsky.
Thank you, Mr. Waxman. You know, Republicans ran on the promise of smaller government. But in fact, it looks as if they want to reduce the size of government to make it just small enough so that it can fit in our bedrooms. This extreme legislation is an unconscionable intrusion into the important and often wrenching and often devastating life decisions of American women and their families. Not a single American woman's rights are safe under this extreme bill. Already, the Hyde Amendment, unfortunately, makes sure that poor women and federal employees and military women can't get the full benefits under the federal plans. But what this says is that women with their own money will be restricted from purchasing full reproductive services, including the right to terminate a pregnancy. It does raise taxes on businesses and individuals. 163 Republicans wanted to change the definition of rape. I think that's out of that bill now, saying it can only be forcible. You have to prove that you were beat up, I guess. And this can deny emergency care to save a woman's life. Let's do what the American people want. Let's create jobs. Let's get to the business of the economy and start limiting the rights of women in America.
The chair thanks the members for their statements, and we'll now turn to our witnesses. Each of you has prepared statements that will be a part of the record, but I ask that you summarize your prepared statements in 5 minutes. Our first witness is an associate professor of law at George Mason University School of Law, Helen Alvarez. Professor Alvarez received her law degree at Cornell University in 1984 and a master's degree in systematic theology from the Catholic University of America in 1989. She has practiced law with the Philadelphia firm of Stradley, Ronan, Stevens, and Young, specializing in commercial litigation and free exercise of religion matters. She also worked for the National Conference of Catholic Bishops, drafting amicus briefs on abortion and a variety of U.S. Supreme Court cases. Next, we will hear from Professor Sarah Rosenbaum, a Department of Health Policy Chair from George Washington University. Professor Rosenbaum received her Juris Doctorate from Boston University Law School and has focused her career on health care access for low-income, minority, and medically underserved populations. She also worked for the White House Domestic Policy Council during the Clinton administration, where she directed the drafting of the Health Security Act. While serving on numerous national organizational boards, she has also co-authored a health law textbook, Law and the American Healthcare System. Finally, we will hear from Douglas Johnson, Federal Legislative Director from the National Right to Life Committee, who will offer his testimony. Mr. Johnson has served as the Legislative Director of the NRLC since 1981. Over the past several years, Mr. Johnson has written extensively on the abortion-related issues raised by various bills to restructure the health care system, including the Patient Protection and Affordable Care Act. He has also published extensively on other right-to-life issues, including partial birth abortion, fetal homicide, and human cloning, as well as on issues relating to restrictions on political free speech and critiques of how the news media covers some of these issues. So at this point, I'll recognize Ms. Alvarez.
Thank you, Mr. Chairman. Good afternoon, and thank you for this opportunity. My testimony today will address conscience protection in health care under the Protect Life Act. Initially, I want to say that there's no need for us to view the matter of conscience protection as a zero-sum game between conscience-driven healthcare providers and the patients they serve, particularly the most vulnerable. Opponents of conscience protection are portraying the situation this way, but the opposite is true. It's by protecting conscience and elevating respect for life in healthcare that we're likely as a nation to serve and reflect the values of most Americans, particularly the vulnerable. This can be understood from several angles. First, less privileged women are less likely to support abortion or abortion funding than their more privileged sisters or than men. They're also less likely to abort their non-marital pregnancies than more privileged women. Second, abortion has not mainstreamed into American health care even 38 years after Roe. It remains, in the words of the New York Times, at the margins of medical practice. This, I believe, is why opponents of conscience want to force the government and conscience-driven providers to give them what the market has steadfastly refused: dispersed sources for abortions in hygienic medical settings. Instead, today we have this: 87% of counties with no abortion provider. A small percentage of doctors willing to perform it, according to the Guttmacher Institute, because of stigma issues. 95% of abortions delivered in clinics and not hospitals or doctors' offices. Just recently, even an affiliate of Planned Parenthood, our largest abortion provider, quit the national organization over its insistence they provide abortions. Finally, there are the regular reports of unhygienic or even horrific conditions at abortion clinics. In recent weeks, we can't have missed the reports about Planned Parenthood employees offering to cooperate with someone posing as a sex trafficking ring director of minor girls as young as 13. Planned Parenthood has acknowledged it needs nationwide retraining. Third, there's an emerging scientific and cultural willingness to conclude that abortion is killing and not health care for women. Not only is this the word used by a majority of our Supreme Court, but abortion providers and supporters of abortion rights are using it regularly. More broadly, and I think this is new, with respect to women's flourishing, there is emerging a critical mass of evidence from respected scholars and peer-reviewed journals that more easily available abortion is associated with women's what they're calling immiseration, that is, making them miserable, not their flourishing. Associate, that is, with creating a market for sex and mating that demands more uncommitted sexual encounters, contrary to women's empirically demonstrated preferences, thereby producing more sexually transmitted diseases, more non-marital pregnancies, more single parenting, more abortions, more poverty. Women of color, immigrants, and poor women are suffering the most from this. If opponents of conscience protection want to encourage high-quality health care for women, they couldn't do better than ally themselves with supporters of conscience. These are the kinds of providers and institutions with a thick sense of vocation and a record particularly of assisting vulnerable women. These are not the providers we want to drive out of health care. The Protect Life Act will assure that conscience-driven providers remain in this marketplace. It adds protections for them which reinstate the status quo but were not present in the Affordable Health Care Act. It adds protections regarding training for abortion and protects health care entities and providers against discrimination by governments and federally funded institutions, an important oversight. It explicitly protects existing state conscience protections from federal preemption. The Affordable Care Act also lacks sufficient enforcement mechanisms in connection with the limited conscience protections it did offer. In conclusion, the freedom of religion and moral conscience is enshrined in the Universal Declaration of Human Rights. Our own President Obama has urged, I quote, secularists are wrong when they ask believers to leave religion at the door before entering the public square, unquote. Our founders understood that human beings require respect for conscience as a condition for living in freedom and integrity. Our founders knew, and we know, and we can even measure it today, the relationship between the flourishing of religion and moral conscience and a good society. When it comes to abortion, conscience protection in some form has been the common ground between all sides of the debate, even before Roe. Even when abortion was legal before Roe, conscience protections were attached to it. Our Supreme Court called them in Doe versus Bolton appropriate. So it is contrary today to common sense those insisting that health care providers check their consciences at the door. This should be recognized for the marginal and dangerous opinion that it is. Thank you.
Thank you. Please pardon the interruption to the witnesses, but a vote has been called on the floor. There are 2 votes, so the committee will stand in recess for votes and reconvene 15 minutes after the last vote to resume the hearing. Thank you. The committee's in recess. The hearing will come to order. Thank you for your patience. To the witnesses, as the members were called to the floor for a vote. We've heard from Professor Alvarez. Next, we will hear from Professor Sarah Rosenbaum. Welcome.
Thank you very much, Mr. Chairman and members of the committee, for providing me with the opportunity to speak before you today. The Hyde Amendment and existing conscience protections both were expressly incorporated into the Affordable Care Act through Section 1303 in order to ensure the preservation of conscience and to protect against public funding for abortions. The Protect Life Act would dramatically expand the reach of abortion prohibitions beyond the furthest limits of the Hyde Amendment by incorporating its prohibitions directly into the Internal Revenue Code. The bill would achieve this result by amending the ACA to bar the use of premium tax credits, even though these credits must, in many cases, be repaid from personal income if earnings increase, for privately purchased health insurance products if those products cover medically indicated abortions for which federal funding is barred, and even if the abortion coverage is paid for out of private income. This would be an enormous break from the existing provisions of law, which allow tax credits to be used for products, even if those products cover medically indicated abortions, so long as that component of the product is purchased with private funding. This change would produce 3 results. For the first time, the IRS would be required to assume major policymaking and enforcement responsibility where federal abortion policy is concerned. Among its responsibilities, the agency would be obligated to develop implementing policies that define critical terms. The IRS would have to define abortion in order to separate allowable claims, such as claims related to spontaneous abortions and miscarriages, from prohibited claims for induced abortions that fall outside allowable federal legal parameters. The IRS would have to define rape. It would have to define incest. It would have to define what is, quote, a physical disorder, physical injury, or physical illness that would, as certified by a physician, place the female in danger of death. The IRS would also need to establish a plan certification system to assure front-end compliance as well as medical audit procedures for measuring corporate compliance. Second, health plans could be expected to exit this optional coverage market entirely rather than expose themselves to IRS standards, audits, disallowances, and exposure for potential legal violation. The law would continue to permit, but of course not require, a plan to cover certain distinct types of abortions, but the consequences of crossing the line for a plan would be potentially so severe, i.e. loss of the right to sell qualified products in exchange, that there is really no business reason to risk this kind of corporate exposure. This is particularly true given the weak market for this kind of a product, that is, a supplemental product, in view of the modest income of so many people who will be buying their coverage through exchanges. Women also conceivably could risk loss of coverage of abortion, of important health care, if they buy abortion supplements, ironically. A health plan could deny claims that in the plan's view fall within what the plan would consider an abortion-related exclusion as defined by the plan. Clearly, such an exclusion would apply to treatment of the after effects of a medically indicated abortion, whose aim is to restore a woman's health in childbearing. So, for example, if an abortion undertaken for physical health reasons resulted in sepsis, the plan would potentially exclude treatment of sepsis and aftercare for sepsis because it's related to the abortion. Another example would be follow-on treatment for stroke-level blood pressure triggered by a pregnancy that is terminated for health endangerment reasons. The plan conceivably could deny ongoing treatment because the blood pressure was a condition brought on by a pregnancy that ended in an excluded abortion. While such a decision may be reversed on appeal, critical care could be lost. Finally, the Conscience Clause provisions bear focus. They accomplish three goals. First, they explicitly strip legal protections from entities that are the subject of discrimination because of their willingness to provide lawful abortions. Second, the provisions create an express private right of action for both money damages and injunctive relief against state and federal governments for actual or quote-unquote threatened violations of the law without definition. Third, the non-discrimination provision raises great uncertainty around EMTALA. While uniform enforcement of EMTALA's screening, stabilization, and medical transfer requirements against federally obligated hospitals constitutes anything but discrimination, in my view, if you're enforcing the law uniformly, you are not discriminating. The fact is that the newly recodified provisions without clarifying language raise troubling questions for administrative and judicial enforcement. I have the utmost respect for religious health care institutions, but the literature, including articles published in the peer-reviewed literature, demonstrate instances in which crucial treatment involving pregnant women was withheld or delayed over what is termed conscience. EMTALA is a paramount protection unique in all of health law, and in my view, Congress should take no action that begins, for any reason, the long unraveling of its absolute safeguards.
Chair, thanks, the gentlelady. And now for the final witness, Mr. Douglas Johnson.
Mr. Chairman, before I begin, I'd just like to note that we're not getting any time information. This device is not working, so if you could give me some sort of 90-second warning, I'd appreciate it.
Marty.
Chairman Pitts, distinguished members of the subcommittee,
On the table.
I am Douglas Johnson, Federal Legislative Director for the National Right to Life Committee, or NRLC. NRLC is the Federation of State Right to Life organizations nationwide. NRLC supports the Protect Life Act, as well as the more comprehensive government-wide approach incorporated in the No Taxpayer Funding for Abortion Act, H.R. 3. The Protect Life Act would correct the new abortion expanding provisions that became law as part of the so-called Patient Protection and Affordable Care Act, or PACA. That law contains multiple provisions that authorize subsidies for abortion, as well as provisions that could be employed for abortion expanding administrative mandates. Some of these objectionable provisions are entirely untouched by any limitation on abortion, while others are subject only to limitations that are temporary, contingent, and or riddled with loopholes. Federal funding of abortion became an issue soon after the U.S. Supreme Court decision on Roe v. Wade, and by 1976, the federal Medicaid program was paying for 300,000 elective abortions annually. If a woman or girl was Medicaid eligible and wanted an abortion, then abortion was deemed to be, quote, medically necessary and was federally reimbursable. Unfortunately, that pattern was generally replicated in other federal health programs. And so beginning in the late 1970s, Congress applied restrictions to nearly all of them, but this was done in a piecemeal, patchwork fashion. And many of these protections were achieved through limitation amendments to annual appropriation bills. This is a disfavored form of legislation. For one thing, the limitation amendments expire with the term of each appropriation bill, which is never more than 1 year. Some of the pro-life policies have in fact been lost for varying periods of time because of their transient nature. For example, because of the actions of the 111th Congress and the Obama White House, today, congressionally appropriated funds may be used for abortion for any reason, at any point in pregnancy, right here in the nation's capital, and that is being done as reported in today's Washington Post. We believe that when Congress creates or reauthorizes or expands a health insurance program, it should write the appropriate abortion policy into the law, as was done with the S-CHIP program when it was created in 1997. During the 111th Congress, we strongly advocated that all programs created or modified by the health care bill should be governed by explicit, permanent language to apply the principles of the Hyde Amendment to the new programs. I wish to underscore here what many have tried to obscure. The language of the Hyde Amendment prohibits not only direct federal funding of abortion, but also funding of plans that include abortion. I would refer to my written testimony in footnote 10 for the full text of the Hyde Amendment, and you will see that it refers to funds that go to any trust fund from which includes coverage of abortion. And this is explicitly defined to include the package of services covered by a managed care provider or organization pursuant to a contract or other arrangement, end of quote. Very similar language is found in the abortion-related provisions that govern other federal health programs, for example, S-CHIP and the Federal Employees Health Benefits Program. This exact language is in footnote 12 of my written testimony. I have also submitted to the committee a 24-page affidavit that I executed that explains 4 of the major components of the PACA that authorize subsidies for elective abortion. It focuses primarily on 1, the pre-existing condition insurance program, 2, the federal tax credit subsidies for private health plans that cover elective abortion, number 3, authorization for funding of abortion through community health centers, and number 4, authorization for inclusion of abortion in health plans administered by the Federal Office of Personnel Management. And, Mr. Chairman, that is not an exhaustive list. To summarize, in the PACA, there's nothing on the way that remotely resembles the Stupak-Pitts Amendment. Instead of bill-wide language to permanently apply the Hyde Amendment principles, we find a hodgepodge of artful exercises in misdirection, bookkeeping gimmicks, loopholes, ultra-narrow provisions that were designed to be ineffective, and provisions that are rigged to expire. We find abortion authorizations that are permanent and limitations that expire. As to President Obama's executive order, it is a hollow political construct. As discussed further in my written testimony and in the affidavit, it consists mostly of rhetorical red herrings, exercises in misdirection, and was characterized by the President of Planned Parenthood as a symbolic gesture.
Thank you. Chair thanks the witnesses for their statements. Your entire written testimony will be made a part of the record, and at this time we will go to questioning for the members of the committee. The Chair recognizes himself for 5 minutes for questioning. First for Professor Alvarez. If Catholic hospitals were to lose their tax exemptions and have to close their doors because they refuse to perform abortions, what would be the impact on the poor, particularly in the urban areas?
Thank you. While I can't claim to be a representative of Catholic hospitals, I do know that there is information that you can easily access regarding their services in poor areas. Just as one example that I brought with me today, the third largest Catholic hospital system in the United States, its statistics alone, 19 states, 73 hospitals, $590 million in charity care, and a great deal of loss as a result of that because of the charity care. It is nonprofit, and they regard themselves as having a particular commitment to the poor, to free clinics, to education and research. These hospitals have empirically demonstrated that they provide the kinds of services to women and the poor in particular that are exemplary and are thought to be superior in many ways to other kinds of hospital systems.
Thank you. Mr. Johnson, in your testimony, you estimated that more than 1 million Americans are alive today because of the Hyde Amendment limitations on government funding of abortions. What would be the effect of authorizing government funding of abortion nationwide as a routine method of health care?
Mr. Chairman, this estimate is based on studies done by the Guttmacher Institute and other critics of the Hyde Amendment. And they have given figures, the lowest figure being the reduction in abortions among Medicaid-eligible populations has been on the order of 1 in 4. There have been some estimates as high as 1 in 2. But if one takes even the lowest estimate, the 25% figure, and extrapolates that over the life of the Hyde Amendment, there are indeed more than 1 million Americans alive today because of that policy. So we've heard President Obama speak about his desire for abortion reduction. We believe the Hyde Amendment has proven itself to be the greatest domestic abortion reduction policy ever enacted by Congress. And yet, it's been characterized by a 2007 Guttmacher Institute monograph as a, quote, tragic result of the Hyde Amendment, these 1 million births. Mr. Chairman, we think it stands to reason if the Hyde Amendment is overturned or effectively circumvented by these mechanisms in the PACA, the effect is going to be more abortions, not abortion reduction. We think that anyone who thinks that the million-plus Americans who walk among us today because of the Hyde Amendment constitute a tragic result should vote against your bill. But those who believe otherwise, we respectfully submit, should vote for it.
To follow on, Mr. Johnson, given that President Obama and the 111th Congress greatly expanded the role of government in the private insurance market, does it seem reasonable that Congress would correspondingly try to extend the Hyde Amendment and similar measures to prevent taxpayer subsidies for elective abortions?
These principles have been in place with respect not only to the Health and Human Services Appropriation Bill and Medicaid, but in a great many other programs as well, including, as I mentioned, the Federal Employees Health Benefits Program, which of course covers most members of Congress and their staffs and about 8 million others. With one brief interruption, for the last 24 years, the 200-plus private plans that participate in that program have been required as a condition of participation not to cover any abortions, except life of the mother, rape, and incest. It is not a bookkeeping scheme like you find in PACA. It doesn't say they can, no, it says they can't participate in the program if they cover any abortions. And, the scenarios that we've heard spun out about how it's impossible for insurers to handle this, the IRS will never be able to administer it. The experience of the Federal Employees Health Benefits Program itself, I think, disproves these sorts of fanciful scenarios.
In other words, under the Federal Employee Health Benefits Plan program now, you can purchase abortion coverage with your own money. Is that correct?
Within the program itself, there is no abortion coverage. It is prohibited by the limitation on the annual appropriation bill. Insurers are not required to cover any abortions to participate in the program, but they are forbidden to cover any other than life of the mother, rape, and incest, and that has been the case for almost a quarter of a century. Now, there's nothing, of course, to stop any private individual from going out and purchasing abortion coverage with their own resources on the private market if they choose to do so. I suspect from the data we've seen that very few people do that.
Thank you. Chair, thanks, gentlemen. And now recognizes the ranking member, Mr. Pallone, for 5 minutes for questioning.
Thank you. I want to ask each of the panelists just a yes or no answer. There's a lot of frustration by myself and on the Democratic side of the aisle that, we're in the midst of a recession. Maybe we're getting out of it, hopefully, but it's still out there, and that we should be spending our time focused on the economy and on jobs. And in all honesty, just like the health care repeal, I don't see that even if this bill passes the House, it has any chance of garnering 60 votes in the Senate or being approved by the President. So I just wanted to ask you, is there anything in this legislation that creates jobs? Just a yes or no, and then I'll move on. Start with Mr. Johnson. Yes or no, does this legislation in any way create jobs?
Mr. Pallone, I have no competence to answer that question.
All right. Ms. Alvarez, I'll just move on.
Or do I? I'm here to testify on conscience.
Okay. And Ms. Rosenbaum?
It doesn't appear to me that it does.
All right. Thank you. Now, let me ask, is it Alvarez? Is that how you pronounce it? No, I'm sorry. This is for Dr. Rosenbaum, and I'm going to come to you if I have time. The EMTALA statute prohibits hospitals from dumping a patient who is medically unstable. If a patient arrives in a life-threatening situation, the hospital must treat them until her life is no longer in danger. The health reform law made clear that the conscience protections that were written into the law did not repeal or amend the basic EMTALA provisions requiring hospitals to treat a patient until she's stable. Now, the Pitts legislation changes that. It says that EMTALA is subject to the abortion provisions. So, Dr. Rosenbaum, what does that do? Does it mean that if a pregnant woman's life is in danger and the medically indicated response is to terminate the pregnancy to save her life, that the hospital can refuse her emergency care or to refuse to transfer her to another facility that would perform such a life-saving procedure?
As long as the later amendment, this amendment is unclear, the impact of EMTALA, the impact of the amendment on EMTALA is similarly unmeasurable at this point. To the extent that the statute raises questions about whether or not EMTALA applies, and also creates a federal right of action to seek an injunction against the actual or threatened enforcement of a federal law that discriminates against a hospital. An administrative agency and a court would face a very difficult situation in which they would have to reconcile the language of EMTALA, which seems to be an obligation on the part of hospitals, against an express authority now in the statute to be able to essentially evade what is an EMTALA obligation, which is, of course, stabilization or medically appropriate.
But my fear is that if this bill were to pass, and again, I don't see how that happens, but if it were to become law, that you could have a situation where the hospital can refuse the woman emergency care or refuse to transfer to another facility that would perform save her life.
It would appear that way. I mean, this is the problem. It's a later amendment that does not clarify how it is to be applied in an EMTALA situation. And so a court or an administrative agency would be faced with a very difficult question, and it would seem to imply that the later legislation actually alters the EMTALA provision.
And so that could happen.
Yes.
Okay. Now, let me ask Ms. Alvarez. You say that the bill before us today would protect individuals and entities who are not willing to provide all medical choices to women and their families, even in life-saving situations. Now, this is the conscience aspect. Why shouldn't these protections apply equally to all beliefs? In other words, why shouldn't we protect those who believe that they have a moral obligation to provide all medical service choices, in this case one that is legal in the country, to a woman and families? I mean, I'll give you an example. My concern is, Catholic hospital, I guess, a religious hospital that doesn't believe in abortion, administrator or doctor, somebody makes a decision that because of the mother's life that they're going to perform the abortion, and it's contrary to the beliefs of that particular religious hospital. And then they fire them, or they don't hire them because they say that they would perform an abortion in that circumstance. So why aren't we protecting that person so they can't be fired or they can't be discriminated against? Or would you protect them as well?
The first thing is that our laws report that whether in the Harris versus McRae or the Webster decision, our Supreme Court has said that government can favor life over abortion. It can favor bringing children into this world versus taking their lives.
But the bottom line is then you wouldn't protect that person against that type of discrimination.
In 38 years of legal abortion, there has never been a situation, not one, where a woman lost her life because she needed an abortion and didn't get one. So the idea that it's a medical choice is even contradicted by the evidence, let alone by statements by people like Dr. Guttmacher of Guttmacher Institute, who said he really couldn't imagine a situation in which you couldn't deliver the child and protect the mother's life.
But it sounds like you wouldn't be in favor of passing a law that would do that would protect the person.
In 38 years since Roe versus Wade, there has never been a conflict. The Catholic Health Association letter that was referred to as coming in here today indicated that they had never had a conflict in 38 years.
Yeah, but I'm just asking you if you would be in favor of that kind of a law.
You would have to overturn EMTALA then, because EMTALA itself, and I have the provision with me, Section 1395 DDE says, when faced with a pregnant woman and child, you must, quote, stabilize the woman and her unborn child. So I think you'd have to, first of all, change what EMTALA says is emergency care in order to say we'd have to kill to provide care. EMTALA says stabilize to provide care.
I don't think I'm going to get an answer, so we'll move on.
Okay, Chair thanks the gentleman and recognizes the Vice Chairman of the Subcommittee, Dr. Burgess, for 5 minutes.
Thank you, Mr. Chairman. Well, in fact, Mr. Pallone, I think you got your answer. EMTALA, if I understood the comments correctly, actually specifies protection of the unborn, does it not?
Yes, sir, it does. It's 42 U.S.C. 1395 DD subsection E. It talks about if you are faced with a pregnant woman, quote, the health of the woman or her unborn child is in serious jeopardy, you must stabilize them both.
Well, it's interesting that you said in 38 years of law since the Supreme Court ruling in the early 1970s, I was thinking back and trying to remember the specific clinical situation that would have occurred that is being referred to here over and over again. And in 25 or 28 years of medical practice, 4 of which at Parkland Hospital, a major downtown public health facility, it never happened. So I guess sometimes we do try to legislate to the most extreme case, but we're trying to legislate to a case that no one can identify. Ms. Rosenbaum, Dr. Rosenbaum, do you have, you referenced in your opening statement that you have cases from, I think you said from Catholic hospitals where care was compromised. Do you have such a body of case reports that you could supply to the committee? I don't necessarily need to hear about them today, but I would be very grateful if you would supply those clinical situations to the committee so that we might evaluate where those situations have occurred. Because apparently in the legal literature, in 38 years, there's not any. My own personal experience for almost 30 years, there's not any. I just fail to see where are we trying to go with this? And it's well established, again, in EMTALA and in federal statute that the life of the mother, of course, can be protected. So there are extreme problems that do occur. Mid-pregnancy, cancer of the cervix, requiring radiotherapy, well recognized that's going to be deleterious to the pregnancy, but you do protect the life of the mother. Okay, that's a rare occurrence, but it does happen, and it's taken care of under current law, under PAPACA, under the executive order, under all existing conditions today. So again, if you have those circumstances, I pray that you would share them with the committee.
Certainly, I would say they're both actually peer-reviewed literature references, and the case that arose in Arizona last summer involved a woman who was on the verge of death and who was in an early stage of pregnancy. I would also note that EMTALA actually specifies that the obligation to save a life runs independently to the woman and or her unborn child. So it's not a matter of only being able to save them as a unit. It's a matter of having to save whatever life.
Yeah, let me stop you there, because in present-day practice of obstetrics in this country, having to choose between the life of one and the life of the other, as a practical matter, that just doesn't come up. It just doesn't. Yes, there are pregnancies that cannot be saved. We all recognize heartbreaking when they happen. Yes, there are situations where the baby has to be delivered so early that it may have a tough go and may not survive. We all recognize that happens, but it is just rare. I can't, and again, I'm trying to think back in my own volume of clinical experience, which was not insignificant. I cannot remember ever having to stand outside the patient's room with the family and say, look, we got to make a decision here. It's one or the other. Which would you have me save? It just simply doesn't happen. And nothing that we're doing here today, I think, we may add just intellectual discussion, but as a practical matter, I don't think we're affecting anything at all one way or the other. Again, either in PAPACA, executive order, EMTALA, or any existing statute. Let me just ask you, Ms. Alvarez, one quick question. Some opponents of the legislation that is under consideration today seem to suggest that by denying taxpayer funding of termination of pregnancy, that we're denying access to a basic form of health care. Is elective termination of pregnancy a basic form of health care?
I think I wish I had an MD in addition to my JD. In the legal literature, it has been increasingly said, and the Supreme Court's decision in the Gonzalez versus Carhart said it most basically. They referred to abortion as killing. The improvements in embryological knowledge, genetic knowledge, et cetera, that lawyers use in order to come to a hearing like this and make our case in order to make state legislation refer more and more to characteristics of unborn life that place it firmly within the context of being a member of the human family.
And I will just say the 38 years since Roe versus Wade, the game changer has been the refinement of ultrasonography as a clinical tool. What became just something in theory in 1971 is very much reality today, with the ability to look inside and make determinations about the health and condition of a baby well before the time of birth. These technologies didn't exist at the time of Roe. You talked about how this procedure has been pushed almost to the periphery of the practice of medicine, and I think that's a big reason why. Thank you.
Chair, thanks, gentlemen. Chair recognizes the ranking member, Mr. Waxman, for 5 minutes.
Thank you very much, Mr. Chairman. Ms. Alvarez, just to follow up on that line of questioning, abortion is sometimes a medically necessary procedure, medical procedure. Do you agree with that statement?
Again, I'd like to quote Dr. Guttmacher, the founder of the Guttmacher Institute, in 1967, when obstetric care was probably not even as good as it is now, who said, "Today it is possible for almost any patient to be brought through pregnancy alive unless she
Excuse me, I really ask you the question. Do you think that it could be a legitimate medical procedure?
I have to rely on the doctors, sir, and looking
And
at...
what does the doctor says, yes or no?
He says, even if she suffers from a fatal illness such as cancer or leukemia, abortion would be unlikely to prolong, much less save life. I can provide you with additional medical literature.
Well, we do allow abortion under the Hyde language to save the life of the mother. Do you acknowledge that there could be circumstances where the life of the mother would be lost if a termination of a pregnancy didn't take place?
Not having been present when that was negotiated, I imagine that is the kind of thing that in politics is said and is not necessarily have reference to the medical literature. But in the public debate and in public insistence, they want the language of life of the mother.
You would be against abortion under any circumstance. Is that an accurate statement?
I would not, yes, I would not say we could knowingly kill human life.
Okay. Well, I respect that point of view. I respect the idea of a conscience clause. I wouldn't want you, if you were a medical person, to have to perform an abortion, even though some people would say it would be appropriate under the circumstance. And that's why I support this conscience clause idea, because a Catholic doctor shouldn't be required to perform abortions if that individual feels that way. A Catholic hospital shouldn't be required to do it either. The Affordable Care Act is very clear on this point and doesn't provide and does provide these protections for people with a conscience. But let me ask you this: if a doctor in good conscience or a nurse felt that they were morally required to provide an abortion to a victim of rape who requests it, would you respect that as a conscience clause protection?
Again, I prefer what the Supreme Court has said on this, and I'm glad they have, which is that the state can prefer life over abortion. And if a doctor feels that he or she wants to do that, then probably they should steer clear of conscience-driven healthcare facilities as a place of
Well, they have a
employment.
different conscience than you.
They're
They come
free
to a
do it
different conclusion than you do.
Yes.
You want us to protect the conscience of someone out of adherence to the Catholic Church not to perform abortions. Would you respect the fact that someone with a different religious point of view, or maybe even a Catholic as well, who would say, I think it would be morally reprehensible not to provide a victim of a rape a service to terminate the pregnancy. Now, let me ask that of Ms. Rosenbaum,
Could I
because
respond to one thing? I would also,
Sure.
I don't think this is just about Catholics. Morally
not.
pro-life atheists, I hope, would get just as much protection.
You're absolutely right, but people's conscience ought to be respected. It ought to be both ways. If we're going to say we want to respect the conscience of the person who doesn't want to do abortions, I think we have to respect the conscience of someone who feels it's morally required of them to perform that service. Let me ask you about the provision in this bill, because it says state laws can allow insurance companies to refuse coverage of emergency contraception. Well, no, let me go back. There's one provision in this bill that says state laws can do more than discriminate on abortion, because they can look at the conscience on other issues as well. Originally it had conscience related to abortion, but it struck the abortion and said whenever there's a conscience issue, that conscience issue ought to be respected. I'd like to know whether this can be read to say that state laws can allow insurance companies to refuse coverage of family planning and contraception because it offends the company's conscience.
Excuse me, sir, could you tell me which provision that is? Because I came with the Protect Life
Section
Act.
1303 of the Affordable Care Act dealt exclusively with treatment of abortion. And then this bill strikes regarding abortion out. Ms. Rosenbaum, do you know, are you
I do
familiar
know
with
what
the
you're
provision?
talking about now. I'm
Okay,
sorry, would
well,
you like me to
I'd
answer
like an
that?
answer, yes or no answer, because it seems to me they would be allowed, an insurance company would be allowed to say that you can't have family planning or contraception. It seems to me that state law can also allow insurance companies to refuse coverage of emergency contraception, like a morning after pill. It seems to me this could be read to say that state laws can allow insurance companies or doctors to refuse treatment of people with AIDS because homosexuality or drug use offends their conscience, or that we can allow insurance companies to refuse infertility services because it offends the company's conscience, or not to pay for therapies that are derived from stem cell research because it offends their conscience. Ms. Rosenbaum, am I correct in reading that change as allowing those
I agree, because
state laws?
the heading is altered to eliminate the reference to abortion.
Yeah. Well, I find that
Sure.
troubling. Thank you, Mr. Chairman.
Sure, thanks, gentlemen. Chair recognizes the gentlelady from Tennessee, Ms. Blackburn, for 5 minutes.
Thank you, Mr. Chairman. Ms. Rosenbaum, I wanted to, there you are. Now I can see you. Okay. Catholic hospitals, since we were just talking, looking at that, should they be required to perform all the abortions that you would deem as medically necessary? Because it seems like we're debating and discussing medically necessary, and you all continue to go to that provision. So do you think Catholic hospitals should be required to perform abortions that you yourself would deem as medically necessary?
I think, obviously, there's a wide range of opinion on how the term medically necessary is used. I don't think, I'm actually very strong believer in a conscience clause, and would just clarify that EMTALA itself certainly does not obligate a hospital to provide medically necessary abortion, however we define the term.
Okay, let's talk then about medical students. Medical students that are opposed to abortion, should they be required to receive training in how to perform abortions?
Again, it's my understanding that the various provisions, the various aspects of conscience clauses, we have come to understand them today, are something that everybody believes in, that are actually reflected both in underlying law and in the Affordable Care Act. But I think that's a different question from the very specific EMTALA obligation.
Okay. Do you agree with President Obama? He made a statement that he thinks the use of abortion should be rare. Would you share that view?
As a mother and hopefully a grandmother, I agree emphatically.
Okay. Mr. Johnson, good to see you. I want to ask you about a statement that I have read. It was made by Rahm Emanuel, who had been the chief of staff over at the White House as we had the Pitt-Stupak language last year, and he was giving an interview with the Chicago Tribune with their editorial board. Have you seen that statement, sir? Do you know what I'm referring to?
Yes, I have, Congressman.
Okay. And I thought that it was just so telling when he said, and I'm quoting here, I came up with an idea for how an executive order to allow the Stupak Amendment not to exist in law. So, you know, this is of concern to me when you see that kind of language. And I just ask you, sir, when you look at that, is that executive order addressing abortion funding insufficient to ensure that taxpayers are not going to end up footing the bill for abortions?
The executive order is a hollow political construct. The president of the Planned Parenthood Federation of America described it as, quote, a symbolic gesture, end of quote. I think these are two ways of saying the same thing. We could go through it section by section if we had time, and I do in my affidavit that I referred to earlier, which is available here and on our website. But in substance, there's a great deal of rhetorical misdirection in the first section. The actual operative language only speaks to two of the many abortion-implicating components of the PACA itself. In one case, it merely reiterates the objectionable language that allows the tax credits to be used to purchase plans that cover elective abortion. And in the other case, it purports to put a restriction on abortion funding through community health centers, but there's no statutory basis for it, and so it's doubtful that they could make that stick if it ever became an issue. The other provisions in the bill, in the PACA itself, which implicate abortion policy, are not even addressed in the executive order. And so we saw, for example, this summer, the very first component of the PACA to be implemented, the high-risk insurance pool program, once we got a hold of some of the plans that had been approved by HHS, we found 3 of those, of the ones we were able to get, explicitly covered elective abortion. And when we blew the whistle on this last July and a public controversy ensued, after about a week the administration said, okay, they would employ their administrative discretion not to pay for abortion in that program. But they said, and we said, and the ACLU said, and everybody agreed, they were authorized to do so. And they had already approved plans to do so. There is nothing in the bill to prevent it. It was authorized. There was nothing in the executive order that even mentioned it. All of these events are recited in detail in my written testimony and in the affidavit.
Thank you. Yield back.
Chair, thanks, gentlelady, and recognizes the ranking member emeritus, Mr. Dingell, for 5 minutes.
Thank you, Mr. Chairman. Ladies and gentlemen, I heard someone at the committee table, I don't remember who it was, say that that there are a number of subsidies for abortion in federal law. Could you tell me where they are, please? Starting with Mr. Johnson.
There are subsidies for, are we talking about the PACA or other law?
Well, all right, let's take first of all the health care reform bill. Are there subsidies in there?
Yes, we describe them
Where are
in
they
detail
and what are they?
in the written testimony. I just gave one example, the high-risk insurance plan. The administration in July was already approving state plans that covered elective abortion explicitly. They then backed off, but they asserted, and they were correct, that they were authorized to do so by the statute.
All right, now,
they weren't mandated to do so.
right,
They were
let's analyze that. When you subsidize something, you pay more than the cost of it. Is that right? That'd be a good definition, isn't it?
The cost of what, sir?
Well, if I'm subsidizing abortion, I'm going to pay more than the cost of the abortion to the person that I'm giving the money to. Is that right or wrong?
I'm not sure I follow you, sir. If that's
in the farm bill, we give a subsidy, and there we subsidize farmers for producing goods. We essentially pay them to do that. So where in the health reform bill is there where we subsidize it, where we pay people to have it, where we give them a financial inducement?
This first example, which would be the first in a long list I would give you if I had time, is a 100% federally funded program. It's 100% federally funded. That's where it goes.
But we 100% federally
to purchase
funded
the health coverage for the population that qualifies for this particular program, the pre-existing condition program created by the PACA. Okay. Now,
so
we take it as a premise.
You're telling me that the pre-existing condition prohibition pays a subsidy for people to get abortions?
They were paying 100% of the cost of state plans.
100% of what cost?
They were covering the cost of the health plan, sir. The entire cost of the health plan is being paid by the federal government.
Well, maybe I'm looking at a different section, but I'm curious. The government doesn't pay 100% of that. We simply say, you got to pay, you say to the insurance company, you have to give folks this, you have to give them coverage and may not deny it because they have a pre-existing condition.
No, that's a different part of the law. I'm talking about.
To what do you refer? I'm
talking about. Can you give me the citation? It's the high-risk pool program, the pre-existing insurance.
All right, so the pre-existing, where does that subsidize?
Section 1101. This is for the qualified population. The federal government pays 100% of the cost of their health coverage.
Of the health coverage. Do we pay 100% of the cost of wait, whoa.
And the state plans were explicitly covering
may I finish, please?
All abortions.
Do we pay 100% of the cost of the abortion?
When you pay for...
Do we, just yes or no, do we pay? Or
yes, of course.
We pay 100% of the cost of the abortion?
When the government pays for health insurance, it pays for what the insurance pays for, Mr. Dingell. And if you adopt the view that it's a bottom line issue, look at back when Medicaid was paying for 300,000 abortions a year before there was a Hyde Amendment. Now, every time they paid for one of those abortions, they actually saved the cost of childbirth, which is more expensive than the abortion. So you could say there was no bottom line impact, and that the government wasn't actually subsidizing abortion when they were paying for 300,000 elective abortions a year. We think that would be tortured logic.
With my question and not get off into rather odd dialectics here, if you please. I'm trying to understand if the federal government pays the cost of the overage so that the state may offer this particular benefit to people, how is it that they are then subsidizing abortion? I'm trying to understand.
I'm not sure why you keep talking about the state. This is a 100% federally funded program.
Well, there's actually several programs here, but all right, let's say it's 100% federal. How is the federal government, if they pay 100% of that cost, subsidizing abortion?
If the federal government is paying for somebody to enroll in this program in, say, New Mexico, which is one of the plans, and that plan covers elective abortion, then the federal government is paying for every abortion that's paid for by that plan. How could it be otherwise?
All right, what are the other subsidies?
There's authorizations in the PACA for a great deal, $7 billion in money to community health centers.
So do community health centers provide abortions?
Some do.
How many?
This was disputed. We don't know.
I've got 7 of them in my district, and I'm not aware of one that does.
There is a national project called the Reproductive Health Equity Project, I believe, which is devoted to trying to get them to adopt abortion as part of their regular...
Is that covered by the Hyde Amendment?
It is not, sir, because these funds are self-appropriated in the PACA itself. Now, the President in his executive order purports to say, please don't use those monies for abortions, but there's no statutory basis for it. The Hyde Amendment only covers what flows through the HHS appropriations pipeline. The PACA has a great many new pipelines, self-appropriated.
The gentleman's time has expired.
Thank you, Mr. Chairman.
Chair recognizes the gentleman from Pennsylvania, Dr. Murphy, for 5 minutes.
Thank you, Mr. Chairman. I hope you can see me back there. I just want to clarify the stream and what is the law and not the law. Can federal money such as Medicare, Medicaid, be used to purchase medical supplies at health clinics? Can that be used? Yes or no? Anybody from the panel?
Certainly, Medicare and Medicaid pay for.
Okay, yes, okay. And they can pay the rent and heating and utilities at clinics that perform a number of services, including abortions?
There would be no payment.
Wait, but the same building, it would pay for medical supplies and the utilities and the rent, et cetera, where some types of medical procedures are covered, but also where abortions are also performed. Is that correct?
You could not bill for a prohibited procedure.
But if it pays the rent and the utilities and the medical supplies, you could use Medicaid funds to pay for that, where those abortions may also exist. Am I correct?
No, you could not bill for a prohibited procedure. And
If an abortion takes place and there's medical equipment needed, sutures, scalpels, scissors, clamps, gauze, medicines, can some of those that are paid for in the clinic in one category filing or closet be also used for a woman who may be having an abortion?
Not ideal.
I still don't understand. You cannot bill for a prohibited procedure.
When a clinic purchases supplies, do they have two separate medical supply rooms? One that is paid for, that could the money could come from federal or say taxpayer dollars, such as Medicaid, and another entirely separate funding stream where supplies would come from?
That's the key.
Are they kept entirely separate? Does anybody in the panel know?
Thank you.
See you in about an hour.
All right, thank you, Michael. Oh, Mike? Anything else?
Okay.
Not ready.
I hold in my hand a federal grand jury report about a clinic in Philadelphia, the First Judicial District of Pennsylvania. It's 260 pages worth of shocking and horrifying descriptions of what took place at the Women's Medical Society. It has procedures and lists of things too gruesome to describe about many babies who were born, who were viable, and were left on a table until the doctor would come in and use scissors to sever their spine. The fellow who ran this clinic is up for many charges of murder, although it's estimated this actually took place in the hundreds. Now, I want to show you a document here which is fairly important with regard to this, with regard to how one billed for some of these services. And what it has on this document, it's very interesting, the column of how things are paid for, because it lists some of the prices. Let me see if I can find it here. It lists some of the prices for these services, and in this column it says paid for by Medicaid and for and then part was out-of-pocket expenses. Anybody, here, would you help me find that, please? Anybody know how that could be?
I presume you'd have to ask the Pennsylvania Medicaid program.
Well, I mean, the thing that's real difficult for me is we're told it's illegal. And yet here's a clinic that's operated for quite a time, billing Medicaid. I want to know how this is, where it has on this price list, and it's broken down by the age of the fetus from 6 to 12 weeks. Under discount price for Medicaid and cash, it's $330. 13 to 14 weeks gestation is $440. When it's 21 to 22 weeks, it's $1,180. Although at 23 to 24 weeks, because it's a 3-day procedure of dilation for a partial birth abortion, it's $1,625. The prices go up according to the age of the baby. But it says Medicaid and cash. And I don't understand how, if we're saying federal taxes don't go towards paying for abortions, I just want to make sure I want to make sure we're not living in a delusional world. Is it used or not?
A state Medicaid program, a state Medicaid agency can use non-federal share funding to pay for a broader range of services.
How do they do that? Do they mark the bills that come from the federal government and separate them in a pile?
They literally segregate out claims that would be federally allowed.
So state taxpayer dollars are going towards this. But state taxpayer dollars can go towards these abortions.
I have a different view on this point, Mr.
Yes.
Murphy. First of all, It is not true that the Hyde Amendment allows states to use matching funds in Medicaid for abortions other than life of the mother, rape, and incest. This is explicitly prohibited by the text of the Hyde Amendment, which, again, the complete text is footnote 10 in my written testimony. But a state may set up a parallel program with entirely state funds. Technically, it is not Medicaid, as Dennis Smith, the former administrator, has pointed out, to cover whoever they want with entirely state funds. But Pennsylvania has not done so. Pennsylvania, in fact, has resisted even the expansion due to rape incest back during the Clinton administration. So I can't explain the document that you have in your hand. I think that does bear further investigation. And it really illustrates how, particularly with respect to late abortions, a lot of the things that we're told, statistics and so forth, are highly suspect. I mean, you're told that late abortions are quite rare. Well, even by the Guttmacher Institute figures, there's at least 20,000 a year after the first half of pregnancy in the fifth month and later, but it may be a lot more.
Mr. Chairman, I would just ask, as part of what the committee takes action in researching this issue in terms of how that funding stream was done and look at this, is it an example or not of how taxpayers' funds were used to pay for abortions? Thank you. I yield back.
Without objection, thank you. The chair recognizes the gentlelady from California, Ms. Capps, for 5 minutes.
Thank you, Mr. Chairman. And before I get to my questions, I want to ask unanimous consent to submit for the record statements from NABRAL, an organization opposing this legislation.
Without objection, so ordered.
Thank you. Previously, my colleague, Mr. Waxman, was asking some questions, and I want to follow up on one of his questions to you, Professor Alvarez. Should a healthcare provider whose conscience dictates that they should provide abortion services, just like in Mr. Waxman's example of a woman who'd been raped, you, from your lawyer's point of view, from being an attorney and a professor of law, should that individual's provider's conscience receive the same protection under the law that you support for those opposed to abortion? We're talking about the conscience clause here.
The first thing with respect to this particular legislation is that they are free to provide abortions in the United States. It remains legal. It remains legal throughout pregnancy, and they are free to do it. I would not want legislation that particularly protects their conscience to do it within an institution that doesn't want to do it. They are free to do it anywhere they like, except, of course, within an institution, whether they are religious or just morally opposed to abortion. We prefer, as a nation, life over death. The Supreme Court has allowed states to do that, and if they want to extend conscience protection, particularly to people who do not want to provide abortions, it's because those are the people being forced. The people who want to provide abortion are not
you're referring to an
doing
anti-discrimination law.
People who want to provide abortions are not stopped from doing so. That is the state of our country right now.
Okay. Let me point out that you have asserted also that poor and vulnerable women are often treated by Catholic hospitals, and that the protection of conscience and care for vulnerable women are not opposite values. But this is the situation that Professor Rosenbaum brought up. November of 2009, a 27-year-old pregnant woman brought to St. Joseph's Hospital and Medical Center in Phoenix, Arizona, suffering pulmonary hypertension. To quote the hospital in that case, the treatment, her hypertension was exacerbated by the pregnancy, and the treatment necessary to save her life required the termination of an 11-week pregnancy. This decision was made after consultation with the patient, her family, her physicians, and in consultation with the ethics committee of the hospital. Fortunately, because of the doctor's actions in this case, this woman lived, and that is what you're referring to, and then went home to care for her 4 children. Now, in your testimony, Professor, you described the need for institutions and medical providers to be able to choose against performing healthcare services that they find objectionable. Do you believe that that the hospital should have had the choice in a different situation or with a different set of committees and so forth to let this woman die without a treatment or a referral?
Congresswoman, I think the hospital would disagree with your characterization. The details of this particular situation have never been fully publicly
But you could answer my question as an attorney. Say the details
they said
were...
it wasn't an abortion, Representative.
The hospital... And then make this a hypothetical situation. As a professor of law, in this kind of situation, do you believe that a hospital with the conscience clause who chooses not to perform these procedures should let this woman die, or someone who's hemorrhaging, which is sometimes the case in a pregnancy and only has a few minutes to live, and in some parts of this country, there's not another hospital within the time that would be allotted.
Then, if you believe that, unlike what Dr.
I'm asking you
Guttmacher
to answer
says,
for yourself.
yes, that, but it's premised on the question that you believe this situation could occur. Dr. and Representative Burgess has suggested it hasn't. 38 years of legal abortion.
But the conscience
hasn't.
clause should apply. It needs to apply.
Where we really need some conscience protection in a big way is at the health department officials.
But
that
you're
need
not
to
answering my
investigate.
question, Professor.
No, I think I have, with due respect, that we don't have that situation. It's hypothetical. What's not hypothetical is the dozens of women dying at abortion clinics like Dr. Gosnell's. We need protection for those women. And the situation in Phoenix, as you said,
Let me put it another way. I don't want to interrupt you, but there's such little time. In your testimony, you seem to indicate that an individual with life-threatening emergency has time to Google all the available medical services, and she could get to some other place to find a treatment for her life-threatening hemorrhage. For this woman to receive the care she might need, she would have to do you not think this is an incredibly unreasonable action to expect from a woman in that sort of condition?
I never referenced Googling hospital services in any of my testimony. There's nothing similar to that in my written testimony. What I am telling you is that when it comes to women dying in connection with abortion, we have dozens and dozens and dozens of examples at abortion clinics, but not in a hospital setting. None in 38 years.
I yield back.
Chair thanks the gentlelady and recognizes the gentleman from Georgia, Dr. Gangry, for 5 minutes.
Mr. Chairman, thank you. I want to refer back to a line of questioning that the ranking member brought up earlier. I don't think he's still here, but this is in regard to the questions over conscious protections, and I'm going to address this to Ms. Alvarez. Does the Pitts legislation, the Protect Life Act, does it provide any additional conscience protections that are not included in the Patient Protection and Affordable Care Act, sometimes referred to as Obamacare, or indeed President Obama's executive order? And if so, why do you think those protections should be adopted through enactment of the Pitts legislation before us here today?
Thank you. A good deal of that is to preserve what we always had in the Hyde-Weldon legislation. For instance, specific examples, the Affordable Care Act extended non-discrimination protection with regard to health plans, but not as against actions of government. The Stupak-Pitts Amendment, which was adopted by voice vote by the full Energy and Commerce Committee in 2009, included those protections. Just like Weldon did. It was considered so uncontroversial that it included those on a voice vote. Additionally, and this is where I would appreciate the opportunity to clarify what I believe was Congressman Waxman's fundamental misunderstanding of that piece of the Protect Life Act that talks about regarding abortion. He thought that by striking that language out of the Affordable Care Act and putting other language in, we were actually allowing for hospitals to refuse to provide, or healthcare providers, et cetera, any entity to provide this wide array of healthcare services that he listed. In fact, that was just the striking of a heading, because the heading did not appropriately characterize what went underneath it. And in addition, it was connected with amending the Affordable Care Act to make sure that not only did it not preempt state laws on abortion, but it also didn't preempt those 47 states and the District of Columbia that already have conscience protection on the books. So his reading of that particular piece of Protect Life Act, I would say, is not, would not be what the text is saying, and that what it was doing that the Affordable Care Act didn't do, but now we would have under the Protect Life Act, was to protect all those states' conscience protection.
So Ms. Alvarez, and just in summary, from what you say, clearly your opinion is that what's in Patient Protection Affordable Care Act and also in the executive order does not go far enough in regard to the Conscience Clause. Therefore, the need of that provision, that section of the Protect Life Act in the Pitts bill.
on its face,
Yeah.
textually speaking.
And I think that's a yes, and I'm going to accept that
Yes.
because my time is getting limited. I did want to go to Mr. Johnson. And Mr. Johnson, some have suggested that the current existence of the Hyde Amendment and the President's executive order mean there's no need for the Pitts legislation. Does President Obama's executive order support the Hyde Amendment, and does his executive order address all of the concerns regarding federal funding of abortion?
The reference in the executive order to the Hyde Amendment is just discursive. It's a form of misdirection. Of course, the bill doesn't repeal.
Let me interrupt you just for a second. I will let you answer. And I think that came up a little bit earlier. My colleague from Tennessee, Ms. Blackburn, mentioned the interview that the former chief of staff to the president, Mr. Rahm Emanuel, had in an interview with the Chicago Tribune. He essentially said that, did he not? You go ahead.
Yes, and that's why the president of Planned Parenthood said it was just a symbolic gesture. By the way, I'm sorry Mr. Dingell's not here anymore because my associate handed me the memo from the Congressional Research Service about the high-risk pool program that we were discussing a few minutes ago, and it says, quote, this is a memo from the CRS July 23rd, 2010, and I quote, because the Hyde Amendment restricts only the funds provided under the appropriations measure for the Departments of Labor, HHS, and Education, it would not seem to apply to the funds provided for the high-risk pools, end of quote. And that's why the ACLU criticized the White House when they made the discretionary decision after the public controversy last July not to fund abortions in that particular program. They had the authority to do so under the PACA. They decided not to because of the controversy.
Ms. Johnson, let me interrupt you just quickly in the last 5 seconds I've got. Do you think then that the Protect Life Act is an effort to codify, essentially to codify the language in the Stupak-Pitts Amendment that was passed by this House in November of 2009?
Yes, the bill is patterned very closely on the amendment that passed the House by
much Democratic support.
240 votes, which was 1/4 of all the Democrats, and no Republican voted against it.
Thank you. You're back.
Chair, thanks, gentlemen, and recognize the gentlelady from Illinois, Ms. Schakowsky, for 5 minutes.
Thank you, Mr. Chairman. I wanted to ask you, Mr. Johnson, do you want to stick with your statement that the federal government pays 100% of the high-risk pools?
Yes, and in fact, that statement is up on the Secretary Sebelius's website.
I have in my hand the Illinois plan, the Illinois Pre-Existing Condition Insurance Plan, and it says, how is IPXP being funded? In addition to the federal funds, the IPXP will be funded by premiums paid by enrollees, and here is the whole list of the money that is being paid by the enrollees. This is not a question. I want to say for the record that this is not 100% paid for by the federal government. And if I could just have a yes or no answer to this. Did the National Right to Life Committee support the changes to the Hyde Amendment that were originally included in this bill, forcible rape and regarding incest if a minor?
I can address that question, but not with a yes or no.
Well, it seems pretty simple. Did the organization support those?
We supported the bill as introduced. We also support the current policy, which is incorporated in the Hyde Amendment. I believe that these are, well, Congresswoman, if you want my position, then you'll have to allow me to answer in my own way. We support the policy that is incorporated in the Hyde Amendment. It's not perfect, but we do support it, and we supported the bill as introduced. It's not perfect either. We could discuss the history of how the language was.
I have your answer at any time. but not essential to survival. However, my understanding of the National Right to Life's consistent use of the term elective makes it seem as what we're talking about as frivolous or cosmetic. So let me ask you this. Is it elective if a woman has an abortion because she will go blind as a result of the pregnancy?
The term elective, as it's been used the last couple of years and in testimony today, is a kind of shorthand for abortions outside the scope of the Hyde exceptions, life of the mother, rape, and incest. It's not a moral judgment or an ethical judgment on these other circumstances. It's just a shorthand way.
So in other words, by that definition, elective, if a woman would go blind as a result of pregnancy, that would be outside of Hyde, and that would be elective.
That would be elective, as the term has been used in some of this discourse, as a form of shorthand. It does not, the circumstance you've just described is not to prevent the death of the mother, as you've just stated.
Right, okay, so is it elective then? I want to just get this on the record. If a woman with an ectopic...
I have answered your question.
No, I'm asking another question. Excuse me. Is it elective if a woman with an ectopic pregnancy has the embryo surgically removed while leaving the fallopian tube intact?
What you've described, many would dispute as any kind of an abortion, but if it is to be considered an abortion, it would be considered an abortion to save the life of the mother, and certainly allowed by Hyde. Indeed, this was explicitly in the Hyde language back in the 70s, I believe, or at least in the conference report, but it's never been an issue.
Is it elective if a woman miscarries one of the twins she is pregnant with and terminates the pregnancy of the second fetus after doctors conclude there is no hope for survival?
For whose survival, Congresswoman?
For the no hope for survival of the fetus.
The Hyde Amendment does not permit federal funding of abortion of a child because the child has a poor prognosis or a handicap. The criteria is if the life of the mother would be endangered if the pregnancy were carried to term.
So no hope for survival does not constitute, that would be elective. No hope for survival.
No hope for survival of the child for some time after birth? Is that what you're saying?
That the child cannot perhaps survive the full 9 months or could not survive after birth, right?
The Hyde Amendment does not permit federal funding of abortion as a form of prenatal euthanasia.
Chair thanks the gentlelady and recognizes the gentleman from Louisiana, Dr. Cassidy, for 5 minutes. You want to step back here?
You're allowed to go back.
We'll hold the 5.
Hey, Ms. Rosenbaum. In full disclosure, everybody else, you and I have co-authored a paper before. We have worked together.
I put my mic on for that. We have indeed.
Yes. Now, a couple things. I'm approaching this as a physician because some of this discussion, a woman doesn't go blind from diabetes in pregnancy. The renal retinal syndrome is something that develops over years, and so it's not something that would precipitously occur. And that's just one example how as a physician I've kind of approached this. When I read your testimony, you quoted an article that you had written, so I pulled it up. I have great respect for your writing. And one of the things we're talking about here is medically indicated. And you say a woman has a car wreck, fractures her pelvis, loses the baby. Would the hospital not be paid for fixing the pelvis because the baby was lost? Now, frankly, that would most likely be to save the life of the mother. But I've never heard of a hospital having a problem in such a situation, major motor vehicle accident. Have you?
Let me just be sure I'm following your question.
I'm reading your paper here. I'm sure you're familiar with it. It's regarding the Stupak-Pitts Amendment. It's actually about current law and not about what is proposed. And you say, how will plan administrators distinguish between the abortion procedure and the rest of the treatment? Will the entire cost of a course of treatment, example, surgery to repair a damaged pelvis following an automobile accident, be denied if abortion is part of the procedure?
So,
I've never heard of that happening. Have you?
well, here's the problem. The analysis, which I referenced and also gave sort of shorthand to in my oral statement, focuses on the administrative choices made by health plans when a particular treatment is excluded. Often they will say that other treatments that are related to the treatment.
But see, for example, I'm sure we have experience with Medicaid managed care.
Yeah, absolutely.
If a woman comes in with sepsis following an abortion that normally the Medicaid wouldn't pay for, she paid cash and had a complication and came to the hospital, I have never heard of a managed care plan not paying for the rescue, if you will, of the botched procedure. Have you?
What I am writing about and testifying about is what is absolutely legally within the right of the.
So it's not anything that's empirically happened with a long experience with Medicaid managed care. Rather, it is a what if.
It is the legal implication of having an exclusion. This is once you have a benefit exclusion, then other.
But we have benefit exclusions in Medicaid managed care, which is why I come back to that. Medicaid managed care does not cover abortion.
Correct.
But as far as I know, I've never heard of it not paying for the rescue of somebody who's had a complication following a cash-paid abortion. Have you? Again, I just asked because I don't think you're fear-mongering on purpose, but frankly it has that effect because I've never heard of that, and that's as a practicing physician.
Well, I think the issue in analyzing a bill like this is to identify for members of Congress what the potential implications are. Now, you could address the issue.
Now I accept that. Okay, so I think it's fair to say it hasn't happened, and it's just a question of.
We don't know, at least. There's been no documentation.
I can promise you that would hit the newspaper, but that said, and again, I was struck because I've seen patients, although I'm a gastroenterologist, I know of such patients. Secondly, the ERISA market, there seems to be some concern you have that by doing this, we're going to somehow destroy the insurance market for non-federally somehow connected plans. One, it's interesting that you suggest that a lot of people are going to drop their current coverage to go on a subsidized plan, and I will note that we were assured that that was not going to happen. But nonetheless, as you note in your paper, we have a huge ERISA market. I mean, a huge, 87% of the people are covered by ERISA, and most of those folks have coverage. Maybe as a percent it will decline, but really in absolute numbers it's huge. Are you saying that that will go away?
No. The paper addresses what happens when the same health benefit companies that sell products in, let's say, the exchange market are also selling small group products, employer products in the non-exchange market. A company can only make so many variations on the product itself.
But we certainly know that they do make lots of product variations now. Now, you mentioned, for example, that there's dental and vision, and we all know that, and you say that would be a smaller market. On the other hand, I have no doubt there's an enterprising insurance company out there that will become the coverer for many other companies.
The problem with this particular market is that if you follow both this bill and H.R. 3.
Now, by the way, we're talking actually this is about Stupak-Pitts.
Yes.
So it's actually, you're describing not what would be the effect of this addendum, if you will, but rather what is the effect of the current executive order as regards PPACA now, correct?
No. In fact, I would say this bill would bring health reform into line with what originally was Stupak-Pitts.
Okay, so the original kind of thing that passed by a huge bipartisan, this would bring it into a line with where that was.
This would substitute, at least in part, Stupak-Pitts for what was.
They're clicking behind me. We're through. Thank you very much.
Gentleman's time's expired. Chair recognizes the gentlelady from Wisconsin, Ms. Baldwin.
Thank you, Mr. Chairman. Before I begin, I would like to ask unanimous consent to submit for the record the testimony of Dr. Douglas Lauby, who's the board chair of Physicians for Reproductive Choice and Health.
Mr. Chairman, can I ask to see that before we have that unanimous
Could we
consent
have
request?
a copy of that?
Most certainly.
While we're on the subject, can I see the paper that the previous questioner was referring to?
No.
If I can get a copy of that as well, that'd be great.
Thanks. There's no rush. I just.
All right, the gentlelady is recognized for 5 minutes.
And the result of my unanimous consent request? Have I?
It'll take me a minute to read it. I don't mean to be rude. I'm going to read while you're talking, but I can listen while I read.
All righty. Earlier, I expressed my dismay that our very first hearing of this subcommittee in this brand-new session of Congress wasn't focused on the issues that are most important to my constituents, I would suggest all of our constituents, that being jobs, and many facets of which would be directly relevant to our subcommittee's jurisdiction. But instead, on a bill that rolls back the right of women to make important life decisions. And I think that speaks volumes. And I wonder what else we will see on this issue in the weeks and months to come. Will we see defunding of family planning and access to contraception? Will we see revisiting of the rape and incest exemptions? And on that topic, I'm familiar with the chairman's bill as introduced. I believe it's H.R. 358, and another bill, H.R. 3, that one which is co-sponsored by over half of the Republican conference. In both of those bills, there is a redefinition of the rape exemption that would give insurance companies and health providers new authorities, perhaps you could even argue new responsibilities to decide if a woman has been forcibly raped, and the authority to deny care to victims of incest. You know, it used to be that we told our young daughters and sons, no means no. But now apparently no isn't sufficient. What happens if a rape victim is unconscious? What about somebody who's been given the date rape drug as it's known? Are these people no longer considered rape victims? Now, thanks to Americans, and particularly American women who spoke out against these provisions, we're now considering a discussion draft of the chairman's bill without these provisions. Although I don't have the discussion draft at my desk. I don't know if I'm alone, but were people provided with the discussion? Because I'd like to certainly confirm that that language has indeed been removed, but it doesn't appear to be at our desks with our materials. In any event, let me move on. We know that this language in this proposal is not new. During the debate last year on the health care reform bill, this language was proposed and ultimately again withdrawn. So I guess, Professor Rosenbaum, I would like to explore the impact of this proposed redefinition of rape and incest that was included in the legislation, H.R. 358, a variation of which we're looking at today. Who would make these treatment and coverage decisions for victims of rape? And if this redefinition were to occur, how might it be applied in practice? It's deeply troubling to me.
There would be two levels of decision making. First, of course, there would have to be a structure by which the sellers of the products themselves could certify that they were in compliance with the definitions. And so in this case, because we're talking about a tax advantage plan definition, the IRS would have to define these issues. But then when it comes to individual claims, it would go through a claims appeals process. So if you were a woman who claimed to have had an abortion for a covered purpose, the plan might review the claim and decide that the medical justification, the supporting evidence was not strong enough, and would have legal authority, of course, to deny the claim for that purpose. So it would be an evidentiary determination, just like any evidentiary determination, and then you would go through the appeals process.
What about at the treatment stage? Is there any, what would come into play there in terms of what a young victim of rape would have to share in terms of demonstrating that she was forcibly raped?
If the standard is a forcible rape standard, then one could imagine everything from police reports, which sometimes don't exist in these cases because of fears about coming forward, other evidence of particularly brutal attack, physical tearing, all of the medical, clinical, law enforcement evidence that would surround presumably a forcible rape would come into play, and the insurer would be, labeled as the bad guy, but the insurer would be doing what it legally needed to do in order to adhere to the federal exclusion.
Thank you. And I would renew my unanimous consent request.
Chair, thanks, lady. Is it okay? There's no objection. So with unanimous consent, so ordered.
Thank you.
Thank you, Chair. Thanks, lady. And recognizes the gentleman from Kentucky, Mr. Guthrie, for 5 minutes.
Thank you, Mr. Chairman. My friend Dr. Cassidy was talking about the paper, Ms. Rosenbaum, that you had. And I guess what you're saying, how is the physician going to, if there's an abortion procedure, there's complications with that, and they treat beyond that, how are they going to disentangle what was abortion-related and what wasn't? That was the same question we had with insurance. I mean, if somebody goes into the exchange and they receive a subsidy to go into the exchange, whether they pay 80%, 50%, and some of the argument that was made on the floor, I guess in the Senate, although we did pass SUPAC PITS in the House, was how do we know what portion of that premium is going to be for abortion, what portion is going to be from the federal taxpayer? And without being able to disentangle that, we said, well, you can't disentangle it because it's all tied together, and therefore the intent is to ban this to keep with our idea that the federal taxpayer shouldn't pay for people's abortion. And on that, with Mr. Johnson, and I'm going to try to get this quickly because I want to yield some time. With Chairman Dingell, or Mr. Dingell, you were talking about the coverage. So even if you don't get 100% coverage in the high-risk pool, if you get some percentage of coverage in the high-risk pool, or any exchange, if the exchange offers abortion coverage, and then there's no way to disentangle, just what I was saying, what is a federal dollar and what is a private dollar.
Well, these are two different issues. I think Congresswoman Tchaikovsky and I were talking past each other a little bit. The high-risk pool program, yes, the clients do pay a certain amount in, but it's just like Medicare. Those become federal funds. Those become federal funds. That's why Secretary of HHS on their website says it's 100% federally funded. The state contributes nothing. The clients pay a certain fee, just like in Medicare, but those then become federal funds. The notion that a federal agency can pay out of the Treasury for medical services, abortions or any other, and that is the use of private funds is really a hoax. And we saw an attempt with the CAPS amendment on the bill last year to make that claim, where under the public plan, the Secretary of HHS would have been paying for elective abortions out of the federal Treasury, and they said, but that was private funding of abortion. That's a hoax, and nobody would entertain it for a moment if you were talking about some context other than abortion.
I'm going to yield the remainder of my time to Mr. Burton.
I thank the gentleman for yielding. And in fact, Mr. Johnson, when we had that discussion on the CAPS amendment in the markup of the Patient Protection Affordable Care Act in July of 2009, the Democrats' own counsel characterized that as, he said, it would be a sham, if I recall correctly. It was late at night and after a lot of discussion, but I think many of us were startled when Mr. Barton asked the question. And again, the Democratic counsel said, no, that would be a sham.
We cite in our testimony a host of authorities on this, that these are public funds, federal funds, once they are collected. The government collects money through diverse means, taxes, user fees, these premiums and so forth. They're all federal funds once the government has them.
On just a couple of things that have come up, the issue of a pregnancy located in the fallopian tube, it's just, there would not be a situation arise where that would not be the health of the mother invoked in treating that condition.
Life of the mother.
Life or health of the mother, life of the mother. Whether you use methotrexate as a medical procedure or a surgical procedure, I mean, that has to be treated, and everyone recognizes that. The paper that I asked permission to look at before we accept it in the record does go through a litany of very heart-rendering, difficult situations. There's only one that is referenced in here that really would fall outside the emergency classification where it needed to be tended to, whether it is a hospital that provides this service or not. The doctor is obligated under EMTALA to provide that care, stabilize, transfer to another facility if the condition permits it. But only one of the 6 or 7 cited here would actually fall into the category of elective. And the one that's elective, again, it's a tough story of someone with another child who is ill and decides not to carry their pregnancy, but that's hardly an emergency situation and one that can easily be stabilized and a proper caregiver found. Now, the other issue that's brought up in this paper is the issue about that requirement of a rider would be unworkable. But in fact, that's what insurance is. It's planning for the unplanned. And it does not seem to me to be unreasonable to ask for that to be one of the conditions. And again, the president's pretty clear in his executive order, I think. So Mr. Pitts, I congratulate you. You're trying to help the president, and there's lots of people who would say that that's an evidence of bipartisanship. So I welcome your efforts to help the president and clarify his executive order. And again, I have no objections to including this in the record.
Chair, thanks to gentleman. Recognizes the gentleman from New York, Mr. Engel, for 5 minutes.
Well, thank you, Mr. Chairman. Look, we're all really beating around the bush here, and when we're talking about a right of a woman to choose or the right of
that's the problem. We're still
abolishing abortions in any circumstances, these are very heartfelt and personal views, and I don't denigrate anybody's view on this issue. But I really am very much chagrined that first thing out of the box in this Congress, the majority is pushing forward on wedge issues such as abortion, when we should be doing things like helping our economy and getting people back to work and getting unemployment down. That's, as far as I can see, what the election was about in November, and it's very disconcerting to see these wedge issues being pushed to the fore. Let me get back to basics. Let me first ask Professor Rosenbaum, because we've been back and forth on this. Aside from the narrow exceptions of life, rape, and incest, does the Affordable Care Act allow federal funding for abortion services?
It does not.
Okay, so your reading of it is a lot different from some of the testimony we've been hearing.
I think, and every effort has been made to clarify any circumstance in which there was any question. I can find no evidence that anybody has not clarified that the same standards that we know in Hyde apply under the Affordable Care Act.
In your testimony, you state that the Protect Life Act will affect women's ability to find a health plan that includes abortion and purchase it with her own funds. Can you explain what that implication would mean for a woman's access to health services?
The effect of the Protect Life Act would be, in my view, given my familiarity with the way insurers behave in a marketplace, is that the market for the kind of coverage that one would need to buy essentially totally outside of the tax-advantaged coverage just would never materialize, because the people who are going to get the benefit of the Affordable Care Act's tax-advantaged system are individuals who don't have disposable income. They are, by definition, without the means to buy coverage. That's problem number one. Problem number two is the problem that I alluded to in both the written testimony and the oral statement. Namely, it's very difficult to buy supplemental coverage and have that supplement totally separately administered, because the whole nature of a supplement is that it works in tandem with the basic coverage. Under the Protect Life Act, the only way a supplement can be offered is if it's offered entirely separately, administered separately from the underlying coverage. And as the example actually that Mr. Cassidy provided before, where you have a terrible car accident and you have several things going on at the same time, an injury and potentially an abortion, you could easily end up in a situation where both with the full coverage has to work in tandem in order to work. Otherwise, the supplement and the primary just both deny.
Well, I think that this is another attempt to try to kill the Affordable Health Care Act, and I'm sorry that it uses, this legislation uses low-income and middle-income women as a political football. I just don't think it's right. Professor Alvari, I want to ask you a question. You talked a lot about the conscience clause and conscience protections for hospitals and doctors. I actually do agree with you on a number of things. I don't think that anybody who is opposed to abortion should be forced to perform one, and I don't think that hospitals that for moral or religious reasons don't believe in it should be forced to perform it. That's the conscience. You talked about the conscience of doctors or hospitals, but what about the conscience of the woman who is being affected? If in her conscience, if what she decides and she has to make gut-wrenching decisions, or if the family has to make a decision because of the woman's health, why are we not respecting her conscience? Why only the conscience of the hospital or the doctor?
Thank you, sir. Under your definition of that being her conscience, we do have over 1.2 million abortions a year, with a hugely disproportionate number among the women I think you would consider to be vulnerable that we especially want to take care of. And if you are saying, that, which I would not agree with, that abortion is part of that care, then I think you can rest assured in a rather sad way that the most vulnerable women are getting access to the most abortions. And the conscience protection for them is Roe, Casey, Stenberg, Gonzalez, which allows abortion on demand in the United States.
But you would eliminate that. So where is respect for her conscience?
This bill does not eliminate that whatsoever, and I would also bring up, which I should have before, and I'm sorry, the Church Amendment, which since 1973 has not only said that employers can't discriminate against doctors who don't want to do abortions, but also can't discriminate against doctors who do. Now, they can't do them at a religious or morally opposed hospital, but they are protected by federal law for doing them.
But you would eliminate it, given your druthers, would you not?
Would eliminate
abortion under any circumstances.
That is absolutely true, but this act doesn't do
even with rape
anything like that.
Even with rape and incest, you would say a woman should be forced to go through a pregnancy if she was raped or if there was incest.
I would never punish the child for what other people did, but this bill doesn't come close to reducing abortion in the United States, sadly enough, unless it changes the federal bully pulpit to say abortion is not a preferred service in a way that I hope it will.
Mr. Chairman, before I relinquish, Mr. Towns, before he left, asked me if I would submit for him, for the record, unanimous consent to submit testimony from the National Asian Pacific Women's Forum and the Center for Reproductive Rights. I have it here. I'm doing it on behalf of Mr. Towns.
Could we haven't seen that. If we could take a look at that.
Thank you.
This one. Chair thanks the gentleman and recognizes the gentleman from New York, Mr. Weiner, for 5 minutes.
Thank you, Mr. Chairman. Let's face it. There's a broad gulf. Mr. Engel is right on people's views of abortion, and the Hyde Amendment is one way to come to a conclusion. I don't believe that someone should be denied a medical procedure because of their income. I don't believe that someone who is more well-to-do, who gets enormous tax breaks from the country, that we don't attach to that tax break agreement that they won't get a certain medical procedure. I don't believe we should distribute health care that way. I think it's inhumane and immoral. We have this Hyde Amendment that's supposed to try to strike some kind of a middle ground that I'm not completely happy with and the members of the panel are not completely happy with. But let's agree on what we're saying here. We are not codifying the Hyde Amendment. The Hyde Amendment says that there is an exemption from the restriction of an abortion if a pregnancy is a result of a rape or an act of rape or incest. The bill that the sponsor would have liked to have us pass and probably will still succeed, a pregnancy occurred because a pregnant female was subject to an act of forcible rape, changing the definition of rape, because apparently some rape is more desirable in the eyes of the maker of the bill than others, and includes if a minor in act of incest, so it can't be someone 19 who's that. So there's not any effort here to codify the Hyde Amendment. This is an effort to expand the Hyde Amendment. And, well, frankly, someone caught them this time, but they'll work it in. They're the majority party. They can work this in Rules Committee. We can count on seeing this language again expanding the Hyde Amendment. Don't let anyone who supports this bill ever say to you, I'm for less government regulation. Oh, there's too much government regulation. You've got to be kidding. You can't vote for this thing and then say you're for less government regulation. It's the mother of all government regulations. This is the regulation of an individual woman in a room with her doctor and Congressman Pitts, apparently. I mean, I can't think of a bigger government regulation. So let's agree that in one hearing last week we're against government regulation, and another one this week we're for all kinds of government regulation. If you don't think it's a government regulation, ask a doctor who's got to try to navigate this hearing. God bless the three of you, but it's complicated stuff because you're trying to shoehorn government into what is essentially a basic relationship that revolves around health care. It doesn't revolve around which funding stream is coming. Of course this is complicated. Of course you guys have different views of this. And if you're a physician, and you can't swing a dead cat around here without signing someone, well, I'm speaking from a level of experience. I'm a doctor, therefore I can tell you. I mean, stop that already. The bottom line about this is you're not any particular doctor for a particular client. I don't want anyone who's a doctor here in my operating room. You can just keep with your congressman shtick. It's much, that's better. I mean, what this is about is a fundamental philosophical agreement. And that is that if you are conservative and you believe in smaller, less intrusive government, you've got to take a wild, wild philosophical bank shot to get back into supporting this bill. I don't even know how you do it. I really don't know how you can ever say you're conservative believing you should have this much of government involvement in a medical decision and a conversation. And I do have to say this. I know we read the Constitution that first day we were here, and I'm glad we did. You have to also basically say, if you support this, you don't believe in a right to privacy for at least one half of the country. And that's the bottom line. Now, some people don't. Some people believe to this day, and the right to privacy is my lawyer friends or people who were lawyers and portraying lawyers. The fact is that there is not explicit right to privacy. But I think most Americans of all political stripes believe there's a basic right to privacy. Is there anything more basic than your body? Is there anything more basic privacy there? Well, not according to many people. And that's the conversation here. And if you're on the side of saying, you know what, I think government should have a limit on where they go, I think there should be a limit beyond which they should not pass, this means you do not support this bill. Bottom line. If you believe there's no limit, you can go anywhere. You can get into any personal relationship the government wants to get involved in, they can. We've got a bill for you, and we're going to have others. But I have to tell you something. I would say to my colleagues and friends that if you're going to wring your hands and gaze at your navel about how we reduce regulation in this country, how we get government out of business, try being the business of health care watching this debate. Try dealing with an emergency room a situation where a woman is coming in there and the doctor is saying, you know what, I believe this is a medically necessary procedure, I want to do it, but wait a minute, I got to go through this first. I got to go, and someone gets C-SPAN 9 tapes back for me so I can see if I'm allowed to do it. There's too much government regulation in this. And I think the best thing to do is we should say, let doctors and their patients make these decisions. And as far as I remember listening to healthcare debate, so did my Republican friends way back when, last week.
Chair, thanks, gentlemen. On the issue of the unanimous consent request, without objection.
Mr. Chairman, was there a question in that soliloquy? Should we let our panel respond?
Would one of the panelists like to respond, any of them? Mr. Johnson?
I think you're forgetting someone, Mr. Weiner. What about this little girl here? This is from the grand jury report. You talk about the privacy of the body. What about her body? You're forgetting someone. There's another human individual, a member of the human family who is involved here. That's why it's different than
When you say another, Mr. Johnson, are you stipulating that the woman has rights here?
Of course the woman has rights, including her right to life, but the unborn child is also a member of the human family.
And Mr. Johnson, do you think that a bunch of members of Congress should make that determination where that line is?
We think that the Congress makes laws for all members
So that's
of the
a
human
yes. You
family.
think 435 fairly well-to-do, mostly white men should make that decision?
I think the elected representatives of the American people
Should make this for that woman and that child.
Can I finish my answers?
No, it doesn't sound terribly enticing, no.
All right. Chair, thanks, gentlemen. The chair recognizes the gentlelady from Colorado, Ms. DeGette, for 5 minutes.
Thank you so much, Mr. Chairman. I have quite a number of questions for all the witnesses, so if you can try to keep your answers short, I would appreciate it. Professor Rosenbaum, you've written extensively on issues around insurance law as part of your academic career, correct?
I have.
Now, right now, under current law, is your microphone on? We're having, okay. Under current law, right now, many employers can take tax credits for offering their employees insurance plans, correct?
It is deductible.
And so they are getting a federal benefit for offering their employees insurance, correct?
Indeed.
Right now.
Yes.
And the insurance plans that many employers offer to their employees include a full range of reproductive services, including abortion coverage, correct?
That is correct.
And the Hyde Amendment, as it's currently written, even in the Affordable Health Care Act and the other bills, does not preclude people from getting tax credits for offering insurance plans that offer a full range of reproductive services.
Tax advantage plans are outside the Hyde Amendment.
Now, in addition, most insurance policies don't break out abortion services. They just say any medically necessary services. So if it's legal and it's necessary, then the insurance will cover it, correct?
Correct.
Now, Professor, the Hyde Amendment says that no federal funds shall be used to pay for abortions with the exception of rape, incest, and the life of the mother, correct?
Correct.
And that does not include indirect expenditures like tax credits or tax deductions. Is that right?
not.
So under this legislation, this Pitts bill for the exchanges, and then under this Smith bill, which is also being examined, what it would do, it would go far beyond the established law of current law, which says no direct federal funds shall be used for abortion, and it would then define a whole different set of benefits that people get in the way of tax relief as somehow being federal funding. Is that correct?
Correct.
And so is it your opinion, Professor, that what that would do, in essence, would be to either, if employers wanted to offer people plans in the exchange that offered abortion coverage, they couldn't get the tax credits, right?
Correct.
So then those employers would be paying higher taxes, wouldn't they? Because they wouldn't get
they offered a product that was not tax advantaged anymore.
So basically, employers would be forced to purchase plans that didn't offer a legal medical service that they're offering now in order to get federal tax relief, right?
The other way of saying it is that companies would stop selling products.
Right.
That offered.
And so that's far beyond what the Hyde Amendment says. Okay, thank you very much. Now, Professor Valeri, I wanted to ask you a question following up on what Mr. Dingell and several other people were asking you. Section 1303 of the Affordable Care Act talks about the treatment of abortion under the Act. But under the Pitts bill, this bill that we're talking about today, the words regarding abortion in Section 1303 are struck, and instead the language that says protecting conscience rights is inserted, correct?
That is correct. And
So now, when that is it your understanding, as sort of an ethicist, that conscience rights that conscience rights could be talking about more issues other than abortion? For example, Catholic providers' conscience rights around birth control and family planning and contraception. It could be interpreted that way, couldn't it?
I don't think so,
Why not?
Congresswoman. Because the purpose of that was to strike a heading that was not properly characterizing what went before it, and at the same time to extend non-preemption to state laws, not only regarding abortion and abortion coverage,
I'm sorry,
but conscience.
you can supplement your answer, I apologize. So
That's
you
all
don't
of it.
think so. Okay, Mr. Johnson, I just have a couple questions for you. Now, you've been the head of the National Right to Life Committee since 1981, correct?
No, I am not the head of the National Right to Life
Okay.
Committee. I'm the legislative.
I'm sorry, you're the legislative director. Thank you for clarifying that. Do you support a constitutional amendment to overturn Roe versus Wade? Yes
Our
or no?
organization has supported
Do you
constitutional amendments.
support a constitutional amendment to overturn Roe versus Wade?
Properly drafted, yes.
Yes or no?
I said if properly drafted. There have been many
Yes or no?
amendments. Some we support, some we don't.
Do you support, okay, but you would overturn Roe versus Wade,
We
right?
would overturn Roe versus.
Now, do you agree with Professor Alveri that abortion should be outlawed, correct?
The position of the National Right to Life Committee.
Now, what is your position, sir? I want to know
No,
your
I
position.
represent the National Right to Life
So
Committee.
you're not going to answer that question,
I am
would that
going
be
to answer.
correct?
I'm just testifying on behalf of the National Right to Life
Okay,
Committee.
so what's their position? Do they
That
support
the
banning
exception that
abortion?
should be allowed is to save the life of the mother, if there is indeed
Okay,
such a
okay.
case, which you've heard
So
disputed.
so you would not support an exemption for rape, correct?
That is correct. Our policy.
And you would not
would
support,
not
you as
be-
an organization would not support an exemption for incest. Is that correct?
That is correct.
Thank you very much, Mr. Chairman. I appreciate your comity and letting me participate.
Chair thanks the lady and recognize the gentleman from Ohio, Mr. Latta, for 5 minutes.
Thank you very much, Mr. Chairman. At this time, I'd like to yield 5 minutes to Dr. Burgess.
I thank the gentleman for yielding. Let's just come back to the issue that we're here discussing today, and it's not overturning Roe versus Wade. It is dealing with the aftermath that we were dealt in a very poorly drafted piece of legislation that was signed into law on March 23rd of last year. And because of some of the unfinished business, the way that was pushed through so late in the night, we're here today trying to make certain that we all understand what the parameters are, what's required of each of us, and what the federal government is going to be required to cover and reimburse for. So I do think that while I might agree with Mr. Weiner, and it hurts me to say this, but I might agree with Mr. Weiner on some points. And in fact, with no thought to my personal safety, I would go into an operating room if it were required to save his life, even though I'm licensed and uninsured. But at the same time, what we're talking about here today is the use of federal funds, taxpayer dollars, to fund this procedure. And there have been correctly some parameters and boundaries set around this since 1976. And we are here to help the president see the execution of his executive order and make certain that the spirit of it is upheld, not just this year, but next year and the year after. And even if there is a different president in the White House and a different set of executive orders, that the spirit of this executive order will continue to be carried out. Now, let me just ask a general question, but probably it goes to Mr. Johnson. Does anyone really want to force someone to perform a procedure of termination of pregnancy if it's against their will to do so?
Dr. Burgess, I've heard remarks from both sides here today about no one would want to do that, and I can only implore the members of the committee who really want to explore that issue to read this document. Healthcare Refusals. It's put out by the National Health Law Program, 2010. Professor Rosenbaum was on the advisory committee, which, according to the acknowledgments, played a very active role. It's an amazing document. I just read it myself the other day for the first time. It's about 100 pages. And it is relentless in attacking all forms of conscience laws. They absolutely argue that it is a obligation that should be enforced both on institutions and individuals to perform abortions, to provide abortions. This should be enforced through law, through malpractice law, through licensure requirements, and through diverse other means. There are even attacks on physicians who simply share their personal views about the sanctity of human life with their patients. That is deemed to be a breach of the ethics as defined by these people. The ACLU has a very active project, as Mr. Dorflinger from the Catholic Bishops' Conference testified before the other committee yesterday, to try to compel Catholic hospitals to either get with the program on abortion or get out of town. I mean, they do want to basically drive people out of health care if you will not get with their program and ideology of collaborating and actively participating in killing unborn members of the species Homo sapien. And if you think I'm engaged in hyperbole, I implore you to read this report.
Well, I thank you for bringing it to our attention. Certainly, Mr. Chairman, if the committee could be made a copy of that, I for one, would be happy to look at it. Now, if, Mr. Johnson, if this bill does not pass, well, let me just ask you a question. Do you really think that hospitals are going to not allow emergency treatment for women who show up in the emergency room who are suffering a complication? I mean, we've heard that professed by the other side, but is that the intent of this legislation?
I believe they're going to continue to comply with Impala and just with good medical practice, which is to recognize that they have two patients. And the law could not be more explicit. Professor Alvarez read it earlier. It says you seek to help to save both the mother and her unborn child. It uses that term, unborn child. And I don't see how any fair reading of that law could mean that that's a mandate to take the unborn child out in pieces. Okay?
And I appreciate your answer just because I'm about to run out of time. Again, I want to stress that this law is to put the boundaries in place that the President asked for in the executive order. This hearing, this legislation is not about overturning Roe versus Wade. It is not about doing anything other than helping the President accomplish his goal that taxpayer funding will not be used for the performance of elective termination of pregnancy. Thank you, Mr. Chairman. I'll yield back the
gentleman. Every member was emailed with the hearing notice a copy of the discussion draft. If any of you do not have a copy, we'll be happy to provide it for you. That, in conclusion, I would like to thank all of the witnesses and all of the members that participated in today's hearing. I remind the members that they have 10 business days to submit questions for the record, and I ask that the witnesses all agree to respond promptly to those questions. Again, I'd like to thank Mr. Pallone, all the members for the civil tone of the hearing on such a controversial issue. The subcommittee hearing is adjourned.